Hi, this is Nilgün Zahour from SM JUROR, and today we're going to be looking at the juror misconduct issues in the case of Ramsuer versus Commonwealth, which is out of the Virginia Court of Appeals. Some points that I want to highlight that we're going to discuss are the trial court's duty to investigate or examine jurors, and also whether the adjustment of sound settings or volume settings constitutes extraneous evidence. In this case, the defendant was convicted of rape, sodomy, and abduction with intent to defile. During trial, the Commonwealth played recordings of conversations the defendant had with his mother from jail. Those recordings were admitted into evidence and sent back to the jury room during deliberations to hear from a computer. After his conviction, defendant filed a post-trial motion to set aside the verdict and requested to have a juror testify about juror misconduct based on the fact that jurors changed the audio settings on the laptop to better hear the conversations. He argued that changing the volume transformed the jail calls into extraneous evidence. The motion was denied. Now, when we look at the standard of review when to examine a juror, whether the trial court should examine jurors is a matter addressed to the trial court's sound discretion, and absent an abuse of discretion, its decision will not be disturbed on appeal. Moreover, unless there is a substantial reason to believe that juror misconduct has occurred, a court may decline to question the other jurors in that regard. Now, with respect to the standard of review for a trial court's denial of a motion for new trial, again, we're looking at the sound discretion of the trial judge. However, the principle must be applied with the added caution that only slight evidence of influence or prejudice as a result of such misconduct of a juror should be required to warrant the granting of a new trial. The exercise of a trial court's discretion will not be disturbed on appeal in the absence of a clear abuse, and an abuse of discretion is only found when reasonable jurists could not differ. Now, with respect to the trial court's duty to investigate, again, in considering a motion to set aside when juror misconduct is alleged, the trial court has the affirmative duty to investigate the charges and to ascertain whether or not, as a matter of fact, the jury was guilty of such misconduct. Now, Virginia has Rule of Evidence 2606, which provides that jurors are precluded from testifying as to any matter of statement occurring during the course of a jury's deliberations, and that a juror may testify only as to questions regarding extraneous, prejudicial information improperly brought to the jury's attention as a result of conduct outside the jury room, or whether any improper influence was brought to bear upon any juror from a source outside the jury room. Now, Virginia has been more careful than most states to protect the inviolability and secrecy of jurors' deliberations. The court stated that they have adhered strictly to the general rule that the testimony of jurors should not be received to impeach their verdict, especially on the ground of their own misconduct. Moreover, the unanimous verdict is the best evidence of each juror's opinion of the case. The court stated that they have recognized, however, that there may be exceptional cases where juror testimony might be admissible to impeach their verdict to prevent a miscarriage of justice. But in such cases, that testimony should be received with great care and caution. Now, if we look at the holding in the case, the conviction was affirmed. The adjustment of sound settings did not make the jail call extraneous. And the appellate court noted that there was not a showing of even slight prejudice. Thus, the trial court did not err in declining to set aside the verdict or in not declaring a mistrial. Now let's look at the specific facts which were pivotal to the outcome of the case. First, appellant cited no authority, and the appellate court couldn't locate any, which held that adjusting sound or volume settings on a playback device in order to better hear an audio exhibit constituted the consideration of extraneous evidence. Second, the adjustment of sound settings did not make the jail calls extraneous. Changing the volume does not alter the recording. And finally, because appellant did not proffer anything that rises to the level of misconduct, he is not entitled to further inquiry into whether his proffer was factual. So a further duty to investigate was not warranted. And that's it for our case law analysis of the juror misconduct issues in this case. Again, this is Nilgün Zahour from SM Juror. Thanks for watching. Because the only evidence you want the jury to consider is in the courtroom. See you next time.